Good morning, everybody. This is attorney Marjorie Brunelli, and today I have a guest. I mentioned in the prior video that I recorded in Portuguese. It was a video about construction liens that I was going to invite attorney Michael Garcia to speak because this is his area. So I'm going to let him introduce himself, and then I'll ask him a few questions so we can address, I guess, the questions that I get asked in the office more often. So Michael, it's really nice to have you here. It's a pleasure. Go ahead and introduce yourself. Talk a little bit about what you do.
So first of all, I want to thank you, Marjorie, for inviting me for this interview. My name is Michael Garcia. I'm an attorney here in Florida. My office is in Fort Lauderdale. My specialty is construction, commercial litigation, and government. I do a lot of government work, and that's with construction. But we're here to talk about construction liens. And since I've been in Florida, I've been involved in the construction industry now for the last 17 years as an attorney, as a paralegal before I was an attorney. I also had a notice to owner company that specifically catered to contractors, helping them out with their notice to owners and their liens. And so that's what I do.
Oh, that's interesting. I didn't know you were a paralegal before. I was too.
Yes. I was a paralegal for about 10 years before I went to law school. I was a paralegal in New York, and then I moved down here, and I started working for Larry Libby, which is, he wrote the lien law.
Oh,
So
okay.
I learned from him and the firm about construction and the lien law, and now I'm here with all that experience. And like I said, I own the notice to owner company, which is very important to a lot of contractors because it helps them do their notice to owners, which is one of the first steps in order to perfect your lien rights, to make sure you have rights at the end if you don't get paid.
Right. So let's talk a little bit about that. One of the questions that I get asked here often is, people who are from Brazil. Generally, my clients are from Brazil, the ones that work with construction, and they're generally the subcontractors at a job site. So they'll call and they'll say, I've been working at this job site for about a year, sometimes 6 months, and all of a sudden they stop paying me. So what can I do? Can I put a lien on the property, and how do I go about that? That is the main question that that people ask. So if you can take that question and explain a little bit about how the process works, what the requirements are, just to clarify and provide information. I think it's very needed, particularly in the Brazilian community. And I already recorded a video. We discussed this before in Portuguese to provide some of that information. But since you're the expert, I think it's good to have you speak in English so we can provide even further information.
Yes, so the Florida statute, which is chapter 713, is the lien law statute. The statute is intended to protect your client specifically, all those subcontractors on the job, the smaller guys, the guys that don't have a lot of money to hire attorneys and litigate. The lien law is specifically intended so subcontractors, material suppliers get paid on the job, because the subcontractors are normally not the people that have a contract with the owner. So the way the lien law works is, if you provide improvements to a property and you're licensed, you're entitled to place a lien on the property. If you're the general contractor, you don't need to do a notice to owner because you have a direct contract with the owner. So the owner knows you're there. So if they don't pay, they know they're not paying them, so a lien.
They know the consequences.
They know the consequences. Most owners do not know all the subcontractors because they have no contract with the subcontractor. The contractor is with the GC. So the lien law says if you're a sub on the job, meaning you don't have a contract with the owner, you have to do a notice to owner within your first 45 days of work in order to protect your rights down the road. And like you said, sometimes these guys are on the job 6 months or a year, they've been getting paid, and then they stop. There's a trick here in the industry. A lot of contractors know if the sub doesn't give a notice to owner within 45 days, he has no lien rights at the end. So when it comes closer to the end, if the contractor doesn't pay you, you can't really You can't stop the project, or you can't force the owner to pay you because you have no lien rights. So I tell all my clients, if you're on a job, soon as you start the job, you send a notice to owner from the first day. It protects your rights. It's a very inexpensive thing with notice to owner companies. I use construction notices. I refer everybody there. And they charge about $30 to $45. You send that notice out, and that's all you do. If you get paid all the way through, no big deal. If you don't get paid,
it's very inexpensive. It's
it's very inexpensive. And
right.
look,
So it's definitely something that you need to do, because for $50, you're going to avoid a huge headache in the future.
yes, because what happens is,
Sorry, go ahead.
when you place the lien, it gives, and I tell my clients all the time, when you place the lien on a property, it gives you an attorney a significant advantage and leverage to get paid. Why? Because the lien goes on the property cannot be sold. Sometimes they can't get financing. And if you don't get paid, you can file a lawsuit and you can foreclose on it. And no owner is going to allow his property to be foreclosed on for, $15,000, $20,000, whatever the amount is. They're going to make sure they pay you, or they're going to force that general contractor to pay you. It puts a lot of pressure on the general contractor to get paid. If you don't put a lien, you still have rights, but you only have rights against the contractor, and then you have to litigate for years on end, breach of contract, all this other stuff. Also, the lien allows you to recover your attorney's fees back.
So that's very important.
That's very important, because if you just have a lawsuit against a contractor and you have no lien rights, so all the money that you spend out of pocket, and that's part of the lawsuit that you're going to have to take as a loss. But the lien allows you to recover your attorney's fees. But it's the biggest thing. It puts the property, it holds up the property. It puts a cloud on the property, and you put a lot of pressure on the owner. So example, I represented an electrical contractor. I have a client. We put a lien on the property because he didn't get paid. You know what the owner did? The owner called me. He's like, we don't want any problems. We're going to force these guys to pay you. And that's what happened. The general contractor was being difficult. He didn't want to pay us. But at the end of the day, I told the owner, we don't have a problem with you.
Right.
But if we don't get paid, this is my only option. So the owner went to the general contractor and said, you have to pay them, because if they sue us, you're going to pay us our attorney's fees and everything.
Yeah.
So it puts pressure. It's really important.
Yeah, and it can get really complicated with all the litigation, because I think we've discussed this before. I do a lot of breach of contracts with contract law. Construction lien is not my specialty. Not that, we can claim a specialty without anything specific as your courses. But I do a lot of breach of contract, and back in the day, a lot of foreclosures. So I know that situation well. Things can get really expensive, but if you have an asset such as a real estate property that you can attach, that forces, people to reach a solution.
It forces people, and some people, I want to tell your clients this. Some people look at me and say, really? I can foreclose on a property? I'm like, yes.
Yep.
And it's just almost like a mortgage foreclosure. And sometimes we have even more rights than a mortgage foreclosure, because the statute specifically allows for this. So it puts a lot of pressure. I spoke to a client the other day, and he said, really, they can foreclose on me? I said, yes. If you don't pay them, they're going to foreclose, and you're going to have to pay their attorney's fees and the money that you're owed. And it's one or two things that's going to happen. They're going to pay you the money out of their pocket, or the court's going to take the property and sell it at auction so you get paid.
Yeah.
No owner wants no owner wants to lose the property.
No. Yeah.
Over $20,000, $30,000, because properties are worth a lot more than that.
Oh yeah.
Or even if the number is a lot higher, no owner's going to want that. And on top of that, they have to pay their attorney's fees. So now a $10,000 lien turns into $50,000, $60,000.
Right.
For example, I I represented a subcontractor in Gainesville. The lien was $21,000.
Okay.
They fought us because we were from out of town, right? My clients were from
Yeah.
Miami.
Mhm.
I'm from Broward. We in Gainesville. We won our trial. They ended up paying $70,000
Oh my God, because of $20,000. It's crazy.
because of the attorney's fees, and I had to travel back and forth,
Yeah.
and
It adds
but
up. That's what people don't realize with litigation. It adds up.
but you know
Sometimes
what?
people want to fight and it doesn't make sense to fight.
You know
You're
what? They
better off
paid it.
settling.
You know what? You know why they paid? Because the lien was on a big gym. They were.
Oh,
It was a gym, humongous. The property was worth millions of dollars.
yeah,
Do you
commercial
think
property. Yeah.
you think they were gonna let this property go into foreclosure for 70,000? No, they paid.
No, of course not. Yeah, you're talking about millions. So, Michael, what about the requirements? Because, I think that part of because we can always tell people, hey, here's the statute, go to 713 and read it. But you know how it is. The law sometimes is not clear to people who are not attorneys. It's hard to interpret things sometimes. So,
So
what are
so
the
what I tell people,
requirements, like time-wise, and also the requirements for the subcontractor? What do they have to have? Like what type of licenses? How does that work?
so the first thing I will tell you, and I tell all my clients is 713, a lot of the forms are in there already. If you
Mhm.
want to go in there and use the form, that's the same form I use
Right,
and other attorneys use. I don't change the form. I just use it, but I understand it. Now you can use the notice to owner is in there. A copy of a form claim of lien is in there. Final contractor's affidavit's in there. All the forms that I use in construction regarding the lien law are in there. So clients can go look at that. So the notice to owner, and it's a simple notice to owner. You put the owner's name, you say who you had the contractor for if you're doing. But if you do it wrong,
right.
and I tell people, are you willing to not spend $50 not to protect yourself?
Yeah, it's not worth it.
It's not worth it. So I tell at the beginning of each project, you do it, and it just protects you. $50. So what? You add it into your bid somehow, and into your cost.
Right.
You send it out. So at the end, you're protected because if you don't, for subcontractors, if you don't do the notice to owner, you can't do a lien.
Now, do they have to be licensed to do the notice to owner or no?
No, you don't have to be licensed to be the notice to owner, but you have to be licensed to file the lien.
That's the difference.
Now, let me explain something.
Okay.
When I say license, there are two regulatory bodies. There's the state licensing board, right? And
Right.
then there's a county licensing board. So some contractors can get their license from the state.
Mhm.
Those are the big things: roofers,
Right.
electricians,
Mhm.
stuff like that. Counties, sometimes they have even smaller licenses. They also do roofing, all that other stuff,
Right.
but you can get smaller licenses. So if the county requires you to have a license, you need to have a license. But if there's no license requirement, you don't need to have one. You can still lien. But most things you do need a license. For example, I had someone call me the other day. They provided manpower to the project.
Okay.
They just provided manpower.
Mhm.
You don't need a license to do that. So we can put a lien because you're just providing the manpower.
Right.
And the manpower is going to be used in all different ways. Some are going to be digging holes. Some are going to be sweeping up.
Right.
That's fine. But if the state or the county requires you to have a license, you need to have a license to file a lien. You cannot file a lien without a license. So I tell a lot of my clients, you need to be licensed. And as you know, a lot of some people do good work, but they're not licensed.
Right.
And that
And
creates a
that's the
problem.
thing, right? That's the thing that I talk about on the video. A lot of immigrants, unfortunately, they get taken advantage of because of that. They're not licensed, they don't understand the law. Sometimes they are here illegally, so they're afraid to contact an attorney. And just to clarify that, I'm going to talk in English about that as well, because a lot of people don't understand that. Immigration law is separate from civil court. Like, you don't need to be afraid to contact an attorney because your immigration status is out of status or you're here illegally. You still have the right to contact an attorney, and you still have the right to, for example, file for divorce, file for a breach of contract. That has nothing to do with your immigration status. So you know, I think it's good to talk a little bit about that so people
So,
are aware that they have rights, even though, you know, they're immigrants, so they're not here legally.
yes, look, I do represent a few people that their status is up in the air. As you
Mhm.
said, your status has nothing to do in civil court. Once we're in civil court and we're disputing about money, the immigration status has, for the most
Nothing to
part,
do with
nothing
it.
to do with
Yeah,
it. It's just, did you do the work? Or you owe the money or what have you. So the immigration status is, and look, at the end of the day, like you said, contact the attorney. They'll tell
right.
you, the attorney's not going to lead you down the wrong path that,
Yeah, sometimes it's the fear, you know, because I've had situations where, not only in construction, in other situations too, where, for example, the general contractor or somebody else in a separate breach of contract, for example, I don't know, purchase and sale agreement for something else, that they bought a business, you know, and the person on the other side is threatening them. Oh, if you come after me, I'm gonna call immigration, or I'm gonna let them know you're. So there is always that, even if
that
the
fear.
threat is not, you know what I mean? Like there's always
Yeah,
that fear in the air that somebody's
and,
gonna do something against them.
and in civil court, that's not allowed. We
Right,
can't use that. We can't use that as a threat to say I'm going to report you. And attorneys can't do that.
right,
And
exactly.
as an attorney, sometimes I'll have threaten. I said I can't threaten them. That's against what our
Right,
rules, and we get in trouble for doing that. So yeah, I think the immigrants should not be. I understand that they're concerned, but when we're in civil court, they're not going to worry about that. They're not going to ask you your status or anything. It's the facts of the case that you do the work. Are you owed? Did you do good work or not good work? And that's
yeah.
it. But like I said, the license thing is important for liens. Now, obviously, there are other things that we can do in the law to sue to get
Mhm.
money for our clients if they don't have a license. It just makes it a little bit more difficult for me. I prefer to have someone that has a license because that lien gives me that power. But if I
Right,
don't have it, there's other things I could do. It's probably going to cost the client a little bit more money because there's
and it's
other
gonna take
options.
longer. Yeah,
It's going to take longer. But with the lien, it's important. And I tell my clients that there are a bunch of dates that they need to be aware of,
Mhm.
but that's really for the attorney. There's really 3 dates that are really important for clients.
Right.
One is the notice to owner, 45
45
days
days. Mhm.
from your first day of work, when you started. And I tell clients, it's not when you, it's some people think it's when they actually start physically doing work. It's either that or the delivery of materials. So some contractors will come and they deliver all the materials today, but they start next week.
Right,
The first day starts when you delivered the materials. So I tell
okay,
clients all the time, that's your first day. But I tell them, even if you send it 2 weeks after the project, you're good. You just have to send the notice within the first 45
45
days.
days, yeah. Not 46, not 47,
Yeah,
45, because the statute is very specific.
it's
So if you're like
45.
a day late, you lose your right.
You
So,
lose your rights. And I
yeah,
tell people, don't wait too close to 40
right.
days because then there are other things that have to be done. And I don't want to get really technical about it.
No, no, yeah. Mhm.
So I tell people, within the first 30 days, just send it out and you protect it. You send it out, and then at the end, if they don't pay you, you come see us to do a lien. The second date that's really important is 90 days from your last day of work. The lien has to be recorded 90 days from your last day of work.
And what is the last day of work? Because that,
So
I'm
last day of
sure,
work gets tricky in the law.
right. Mhm.
Substantial completion, TC, there's a whole thing. So I tell my clients, after 30 days, if you haven't been paid,
Do
you have to
something
start
about it. Don't wait.
you
Yeah,
have to start thinking about it. And then some clients want to wait. I said, okay, at 60 days, you should record it.
yeah.
Don't wait anything because at this point,
Chances are they're not going to pay you.
they're not
Yeah,
going to pay you. Here's another thing that's important with the lien law. It's first come, first serve. What do I mean by that? The liens get recorded on the property, right?
yes.
And in Florida, we have the first come, first serve
Oh, yeah. the order
record,
of
right?
recording and, yeah,
Priority, right? So if I have a property and someone puts a lien and there's 10 liens, and let's say I'm forced to sell the property, right?
right,
The first one in line gets all his money. And then if there's enough for the second one, then he gets it, and then there's enough. So the first person that gets to record the lien has that priority,
right.
right? So I tell them, don't wait,
Don't
because
wait. Yeah,
if you're the only if you haven't been paid and there's other contractors on the job, they probably haven't been paid. So everybody's gonna rush to record, and then it's gonna go in priority. Who's first, second,
recorded
third.
first, right. And there
So
might not be enough money to pay you depending
there
on
may
the
not be.
size of
And
the
look,
project. Yeah.
let's say your lien is only $10,000,
Mhm.
but there's a guy with $200,000.
Ahead
But
of
you
you.
get but if you get ahead of him, and the property only has 150, you're gonna get your 10. The other person's gonna get. But if it's the reverse, that guy
Don't
with
get
200,
anything.
he's gonna get everything, and you get nothing.
Right.
So I tell my clients, don't wait. I tell them 30 days. At 30 days, if no one's paying you, you need to start.
Yeah.
You
Taking
need to
action.
start
Yeah.
making action. And I said, at minimum, don't wait 60, because once you get closer to the 89th day, the 85th day,
Yeah.
then we come into, when were you actually there? Was the work considered part of, was that piece of work that you did considered your last day, or was it before? Because
Right.
the word substantial completion means different things in different, under different
And then you have
circumstances.
to spend time trying to prove when your last day was,
Day
if you
was,
filed the
and
lien within the 90 days, and it's just gonna get too complicated. Yeah.
I've had a case where I challenged the lien on that and said, no, your last day was this. So that means your lien is invalid and it's fraudulent. Because
Right.
if you put a lien on a property that's past the 90 days, or there's something wrong in it, they can consider that fraudulent, and then they can
Right.
come after you.
And
So
actually, that's a crime, isn't it? I think that's on the statute. I have to check that because I had like a
so it
real estate
depends.
case a few years back.
Yes, it depends. Most of the time, the crime one is, I did $100,000 worth of work when you only did 50. You exaggerate the lien amount. But if you say, I did 50, but it was only like 45, that's not that big of a deal. But it's like when you exaggerate the number, or you know what you put in the lien is wrong and you sign it, because it's an affidavit. You have to swear to it, and it gets recorded in the public record. So if you know that something in there is wrong and you do it, then we're talking about fraudulent lien.
I'm gonna check though, because I remember doing research on this, and I think depending on the type of fraudulent lien that you put on the property, I think it can be a third-degree felony.
You can.
And there's another one that's a little simpler, but I'll have to check.
Here's the simple example. There was a lady that her husband got arrested, or boyfriend got arrested, or something. And then she put a lien on the state attorney's property.
Wow.
She put a lien on everybody. She's not a contractor. She's not a contractor, and she signed this document, and then she put it for like 100 million, like this number.
Oh my God! Yeah.
So she got in trouble because that was fraudulent.
Yeah.
Most contractors are not doing that, but as a construction, so many subs, they don't have all the paperwork organized as they should be, and then they say something wrong, and then it's proven differently, and then you have a problem. So that's why I tell them, don't wait closer to 90. Wait 30 to 60 days, file it, but you have 90 days from your last day of work.
And some things are just not worth trying to do yourself, because you're gonna need an attorney at some point, anyways. Because if they don't pay you, you have. So let's talk about the other period of time, the 1 year that you have to foreclose on the lien. So if they don't pay, you have to foreclose within a year. And if you don't, you lose that right?
That is,
so you're gonna need an attorney for that. You're gonna need an attorney for that.
That is, you need an attorney for that. That is, those are the 3 days: 45 days, 90 days, and 1 year. You have 1 year from the recording of the lien. So when you record it, you have 1 year to start the lawsuit.
Mhm.
Some people think you can put a lien again. No. In
No.
Florida,
Yeah.
once you put it, if you don't foreclose on it, you lose it. So you have to do something within a year. It's funny because I had someone call me the other day and he's like, well, my roofer said they can put the lien on again. I said, your
My
roofer's not an
roofer.
attorney. I said, he probably knows how to put a good roof on, but he's not an attorney.
Yeah, he's not an attorney, so be careful who you take legal advice from. Yeah.
So,
Yeah.
and the other thing I tell people, do not wait until the 355th day.
Days. Yeah, don't wait until the
Because-
last minute. Right.
Because there are other things that as an attorney, I need to do before I file the lawsuit, but that's for me to worry about. But if you come to me 2 days before the expiration,
Oh,
I will not be able to do the condition precedent, as you know,
Right.
the thing before the lawsuit.
right.
And if you don't do that, then my lawsuit's no good. So I tell
Right.
people, don't wait until the last moment, because sometimes attorneys need to do other things before they file suit.
Right.
And if you don't give them enough time, then the lawsuit's no good.
Right. And then
if
the other
someone
side of
hasn't
that,
paid you-
sorry, Mike, I didn't mean to cut you off. Go
I
ahead.
said, if someone hasn't paid you in a year, in 10 months, do you think?
Don't wait. Right. Yeah. And I think the other side of that we should probably talk about a little bit is if somebody challenges your lien. So if you file it and you're not paying attention to it, someone can challenge it, right? So
Yes,
that can cause all sorts of problems if you don't respond to that challenge. So can you talk just a little bit about that? Let's not go into too much detail.
Yeah. So again, once you file a lien, the owner has two options. They can contest the lien by filing something in the county recorder's office, because that's where it's at. And then that forces you to file a lawsuit within a shorter period of time. So it basically takes your window from 1 year to 60 days. You
Right.
have to file it. There's other ways you can challenge it too that shortens the time frame, lawsuits and stuff like that. But you have to be aware of that. I always tell my clients, once you file this, if you get anything in the mail that's certified mail
Mhm.
from anyone or from the clerk's office or from the
Right.
court, take that to the attorney, because they have to prove that they served it. So normally it's going to come certified mail
Right.
or FedEx.
FedEx.
So if you get
Yeah.
something, take that. Don't wait.
Run with it. Run with it.
Yes, because
To
some
the
things,
attorney's office.
there are other things that they can shorten the window by 30 days. If they
Oh,
serve
wow.
you with the proper paperwork and you don't respond in 30 days, you lose your rights. So I tell people, once we file the lien, you get anything related to this lien,
Keep your eyes open to
Call me,
mail. Right.
bring it to me. When I was a paralegal, I screwed up one time. We had a client and we put a lien, but the client had moved.
Mhm.
And I didn't put the new address for the
Address.
client.
Mm.
I left the old address. They contested the lien and they sent it to the old address,
Mhm.
because that's what
They never got notice.
they never got noticed,
Yeah.
and they lost their lien rights.
Yeah.
My firm had to defend them for free.
Wow.
I got in a little bit of trouble, not too much trouble, because it's like it wasn't intentional.
Right. It was a mistake.
It
Yeah.
was a mistake. They were switching. So I tell clients, if you change address, tell me also, because that's important, because we need
Right.
to update it. Because you don't tell me, and then next thing you know, it goes to the old address, and they don't have to. All they have to show is they send it to you, and that's
Right.
the only address they had. So it's
Yeah.
important to stay on top of it. When you move, tell your attorney, update the information, so if something comes in the mail, you have it.
Right. Yeah, I think the biggest issue that I hear a lot from clients is, they're not getting paid, and then they try to negotiate, and then they waste a month and a half trying to negotiate, and then the GC promises, okay, no, I'm going to pay you, they present a schedule. So, okay, we agree, we're going to pay on this schedule, and then the whole thing starts all over again. Maybe they give them a little bit of money to keep them quiet, and, it goes on and drags on forever and ever. Like, don't do that. Don't wait.
See
That's
what you just said?
do.
That is a perfect example of a contractor trying to take advantage, because
Yep.
they know if they pay you a little bit,
Right.
within that 45 days, you're not going to do the notice. But once
Right.
the 45 days passes, they stop paying, and then you're like, where's my money?
Right.
But you have no lien rights now because you didn't do the first step.
Right.
It's a two-step process for subcontractors and material suppliers that do not have a contract with the owner. It's a two-step process. Step one is the notice to owner at the beginning of the job. And step two is the lien at
Right.
the end if you don't get paid. But if you don't do step one, you don't go to step two.
Right.
So a lot of contractors do that. They'll pay them a little bit. They're like,
Yeah.
everything was good at the beginning. I said, I know, everything was
Yeah.
good. They paid you the first draw, they paid you good, the second draw, and then it stopped.
Yeah.
After the 45 days passed, that's when the issues start, because if they didn't pay you within the first 2 or 3 weeks, you would have contacted an attorney. And
Right.
the attorney would have said, hey, go do this.
Yeah.
So they do exactly what you tell them. They kind of lead them on. They keep giving them a little bit of money, keep them quiet. And then when and
Yeah,
that
it's
happens
the
also.
manipulation, unfortunately, you know.
Yeah,
like
and that
you
happens
just
at the end
play
too.
people. Yeah.
That happens at the end too, right? Because it's 90 days. So let's
Yeah.
say they still have the right. They did the notice to owner. So then they'll straight, okay, project's over. Oh, I gave you some money. Hey, 60 days. Oh, I gave you some more money, right? But now you're
Yeah.
getting money. Then 90 days come. Right before 90 days, they give you a little bit more money. Then once the 90 days come,
They stop paying you.
they
Yeah.
stop paying you, and now you're owed all this money, but you have no right to file a lien.
Right. Yeah. So don't wait. And it's sad that we have to say don't trust what people are saying
No.
unless it's in writing in a signed contract. And even then, because if you don't place the lien, then you're stuck with the signed contract and you got to litigate the breach of contract. It's not the same. You don't have the same power in that situation without a lien. So just the secret is do not wait. Do not wait.
And look,
go ahead.
I will tell you, the law here in Florida is you can never waive your lien rights, because some contracts will say you can't put a lien in it, you can't do this. That's not the law in Florida. No contract in Florida will be enforceable that says you're waiving your lien rights. It's against public policy. There's case law against that, because the statute is specifically meant to protect the small contractors and subcontractors that don't have the money to hire big shot attorneys and defend them. It is there. So no matter what you sign, you never waive your lien rights. The only time you waive them is by not following the statute and the deadline. So,
but that doesn't mean just sign whatever they put in front of you either. Because I've had horrible situations with that. Make sure that you take that contract to an attorney to at least review it and advise you on it. Do not go signing something that the attorney for somebody else prepared, because most likely it's going to be unilateral and beneficial to that party, not to you. So I always tell my clients that do not sign things because you see a big number on that. Oh, they're going to pay me all this amount of money. I'm going to.
Their eyes go like this, Marjorie. They
go, like, they put a dollar sign on there and everybody gets, ooh, I'm going to make all this money. Yeah, no, you're not. So don't go on signing things that you don't understand, because, a lot of it is legal terms. Sometimes it's hard even for us to read it, because they make it so convoluted and so complex. So make sure you speak to somebody. Don't let the excitement, the greed of, ooh, big number, let me just sign this and get it over with. Don't do that. Yeah. Take your time, go to an attorney, and have it reviewed and analyzed. Even if it's just for a consultation, you don't need to spend a fortune, but just to protect your rights. I think that's important.
It is cheaper to talk to an attorney now, to talk to me or Marjorie, to review a contract for a few hours, than to come to us and spend a year or two paying us our fees to litigate.
Yeah. And I'm going to put our contact information. I think it goes below the video. I'm not sure where we're going to post this video because it got a lot longer than I thought. So it's probably going to go on YouTube. I'm not sure. I'm going to try to post it on Instagram, but I'll add all the information for the both of us. And if anybody has any questions, just, feel free to call us, email, or even reach out on social media. That's fine as well. And Michael, I wanted to thank you. Thank you so much for being here with me today. And, giving us this explanation. I think it's going to bring clarity to a lot of people, and I think it's very needed in this field, unfortunately, because of the things we see so much, particularly with the immigrants. But I wanted to thank you. Thank you so much.
No, thank you. But look, I think this section of the law is really complicated. It's just not immigrants. There's also people, Americans that are born here. Sometimes
Oh,
it's confusing.
absolutely. Yeah, it's just because I work with a lot of Brazilians, so I think it's more difficult when you have that issue of, oh my God, I'm afraid because I'm illegal. You know, a lot of times that's the case.
But once they keep those three things in mind, those timeframes, they're protected, and then the attorneys can come in and help them after.
Yeah, absolutely. Thank you again.
Thank
We'll
you.
talk soon.
Yes. Bye-bye.
Bye.